The judgment in the Tsundur case, I feel it is very atrocious, illogical, biased and casteist. The reasoning given by the High Court is contrary to all principles of criminal jurisprudence and appreciation of evidence. The trial court, which gave the first judgment, has elaborately discussed the evidence, the entire evidence, and came to a conclusion which is unassailable. But unfortunately, the High Court, throwing all the norms and canons of justice to winds, gave a very unscientific reasoning which are unknown to criminal jurisprudence and acquitted all the accused. The reasoning, according to the High Court, is one of the reasons is that the prosecution failed to fix the timings of the incident. At what time they received injuries was not established according to the High Court. Those are all immaterial things. We told the judge that these are all immaterial. Only contradictions are, if any, those contradictions shall not be trivial, shall not be immaterial, shall not be material. Only material contradictions can be taken into consideration by the courts. But without any reference to the law, without reference to the evidence, without reference to the principles of criminal jurisprudence, the High Court gave its judgment. It wanted to give the judgment in its own way right from the beginning of the case we heard. It wanted to acquit. That's why right from the beginning, since how long they can wait in the jails, since how long they can languish in jails, that means the High Court wanted to acquit them, release them from the jail without waiting for the arguments in the court. And ultimately, as it was planned, the High Court acquitted all the accused. That's why we objected in the beginning itself that the entire case has to be heard, including the case charged under SC/ST Prevention of Atrocities Act. If the case is heard according to the High Court, in accordance with the SC/ST POI Act, it has to convict them under the Act. The High Court did not want to convict them under the Act. So therefore, it separated. It wanted to separate the case. There is nothing like separation of a criminal case. Whole case has to be heard together with all the witnesses, with all the evidence gathered. But there is no separation of such case. But it separated and wanted to hear the case, and it heard and acquitted them.
Sir, recently there was a news in the newspaper that you would be served a defamation notice, contempt of court.
Contempt of court.
And could you narrate that incident? And also during that period, I was also told that the judge was more interested to hear the culprits' versions, so that you were arguing that why are you not giving space? Could you narrate that incident also?
No, right. Said right from the beginning, the intention of the High Court is to acquit without reference to the evidence. Normally, evidence has to be considered and evidence has to be appreciated in logical way. The High Court did not want to appreciate the evidence, do not want to come to a logical conclusion. Therefore, even the advocate appearing for the appellants was not heard. He was just hurried. Come on. It did not hear the version of the appellants. So then he kept us. Then we said, when we wanted to separate the case, you did not separate. The way in which you are hearing the appeal throws some doubt in our minds. and in the minds of the victims that we may not get justice in this court. Then the court has taken aback and said that this is very serious accusation against us. I said, yes, serious. Then he wanted to issue contempt. We said we are prepared to receive the contempt. Then contempt was issued, not only to us, not only against us, but against the victim also. But we requested the court to release the victim because he is not connected with this whole episode. Since he is a victim, he is under pressure, gave evidence, and he wanted justice to the bereaved, to the victims, and such a person you wanted to issue contempt. Please release him from the contempt and issue contempt against two of us, myself and my junior. And he said, give it in writing. We gave it in writing. When we said we have no confidence in the court, the judge asked us, give it in writing. We gave it in writing that we have no confidence in this court. And this may be posted before any other bench. In spite of taking a written undertaking from us that the court wanted to hear the case, when we said that we have no confidence in the court, normally any court, give away the case, post before another bench, they will say, and it will be posted before another bench for appreciation. But he wanted to, in spite of our repeated sayings that we have no confidence in the court, but he wanted to hear the case. That shows his bent of mind. He wanted to hear the case somehow and wanted to acquit. So because there is no other go for us, we argued before him. We told the judge specifically that subject to the conditions that we have no confidence in the court, since there is no other go for us except to hear, except to argue this case before this court. We are arguing. You please note that subject to that condition, we are arguing the case. He said so, and he heard the case. And at the time of finalizing the contempt against us, he gave it in writing, and he wanted to separate the case from the victim. But in the order, he issued contempt against all three. I told the judge, I brought his notice, that you wanted to issue contempt only against two of us, but why have included again the victim? He said, oh sorry, I will remove him. Then while removing, he said, since you said there was no confidence in the court and you wanted you are prepared for contempt also, and you wanted the victim to separate the case from the victim, from the contempt, then he said, we are also relieving you from the contempt of court. Then we argued the case.
Okay. So, but on the Tsundur initial stage, when the Dalit was a judge, then the upper caste went and the Savarnas went and said that change the judge, we don't have faith, and the government changed him.
Yes.
But when Dalit said that they never changed,
no.
Rather you got a contempt of court.
Yes.
Okay. Now what is the way forward, sir? And what is the victims? Any comments from them?
Victims, they want to take the matter to the Supreme Court.
Okay.
Even according to them, that this judgment is very atrocious. Then they wanted to take the matter to Supreme Court. We also wanted to take the matter to the Supreme Court.
So now this is Telangana is formed.
Yes.
And now this case is in this. If you have to go to Supreme Court, now
yes.
the governor is there.
Yes.
There is no chief minister,
yes.
and the present governor is also not to be seen very democratic. So in that case, what is the way forward, sir?
No, we request the government to file an appeal. That's what the procedure. Since we are appointed by the government as Special Public Prosecutors, we have to make a request to the government law department to prefer appeal. If they prefer appeal, it's well and good. Otherwise, we will file private appeal on behalf of the victims.
Okay, sir.
That can be done. That's what exactly happened in Karamchedu.
Oh,
Karmichedu, the trial court convicted the accused. Life sentences to 6 people and some other similar life sentences, smaller sentences. And they went into appeal to High Court. High Court acquitted all of them, like what happened in Tsundur case. All the accused were acquitted. Then we took the matter to the Supreme Court. Ultimately in the Supreme Court, we got convictions. Probably same thing is going to be repeated.
so then how many more years?
That we can't say. We have to wait for justice, which is alluring us. Justice is alluring us. We are not able to get justice. Even we get justice, that is after 20 years, after everything is over, when the people are not able to enjoy the benefit of the fruits of justice.
So that time they will give the justice.
That is justice.
So now, is there any political motive behind this judgment?
I don't think that there is any political. I can't say, because there is caste work angle in this case. I find caste angle in this case. We did not want to bring this angle at the initial stage, because we thought that the two judges are not, they do not go in that line. But when it happening during the proceedings of the court, we suspected that the caste angle is coming out. The judge is a ready judge. The presiding officer is a ready judge. The accused are all judges, influential judges, that to belonging to coastal Andhra. Then we thought justice may not be done. But we put confidence in the court, taking the gravity of the case. In such case, and in the abundance of evidence, no judge can do any harm to the victims. But enormous evidence is there, law is on our side, but the judges are not on our side. They are on the side of the upper caste people. So therefore we have to wait, we have to fight, we have to continue the fight to the Supreme Court. We expect the Supreme Court that it may do justice. But even if now we cannot say that, we hope that justice will be done as it was done in Karamchudu case.
Thank you, sir.
What exactly you want?
Sir, right now the judgment was given by the special
By the High Court.
by the High Court. By the High Court, that was a result of an appeal.
Yes.
Appeal made by both the parties.
Yes.
So that there was a bench formed to hear these cases
Yes.
of the appeals.
Yes.
So that in that there were two appeals.
Yes.
One was the culprit side, one was another victim side.
Yes.
So right now the judgment is, after hearing the culprit sides and the victim side, the judgment was pronounced.
No, victim side appeal was not heard so far.
But they accepted the appeal.
Appeal is pending.
Appeal is pending.
Yes, appeal is pending.
Okay.
Appeal is pending, and it was numbered, and he said it will be heard. But those appeals filed by the convicted persons, those appeals were first heard. We objected. You cannot separate the appeals like this, because since it's a form of same transaction, and you have to hear same evidence, so you have to hear both appeals together. Then said is separated.
So that one of the appeals from the victim side was that the case was filed under SES POA Act,
Yes.
and the judgment, the police registered the case under POA Act.
Yes.
And the
Charges were also framed.
okay, charges also pure.
Evidence was led in. Finding was there. Conviction was there. But sentence was not there.
So sentence was not on POA Act.
Yes.
So that is why all of you appealed.
Yes. With that appeal is pending against all the accused persons. Those who are acquitted earlier, those who are now acquitted.
Okay.
So about 213 people are there. So this appeal under POA Act is against all.
Okay. So this is not yet heard.
Not here.
So then when are they going to hear, sir? When they released
We'll
everyone?
make a request.
Okay.
We'll make a request.
Thank you, sir.
See, we can't help it. Whole system is in their hands, including the judicial system, their hands. They form their own benches. They make their own judges. They come to their own conclusions without any reference to the law, justice, principles of equity. Nothing is like that.